Karl Konrad and welcome to our weekly edition of Australian Immigration News, proudly brought to you by Australian Immigration Law Services here in Sydney. First up, we cover the incredible backflip of the email advice floating out there by the Immigration Department regarding the validity of the professional year programs known as PYPs. You will notice I do not use the word policy, for as far as professionals are concerned, the only actual policy is what is written in the Department Online Procedural Advice Manual known as PAMS, or what has been publicly released on their website. On the 7th of January, we covered in our news program the email advice issued by the Immigration Department Policy section claiming the professional year program is only valid for 4 years from the day of commencing the course, not the day of completing the course. We explained how this advice was not actually to be taken seriously for several reasons. Nevertheless, the New South Wales government adopted it as it was actual policy and denied potentially hundreds of applicants their 5 precious points for the 190 and 491 visas. The crucial issue was that this advice email was not in line with the reality of many Immigration Department's own publications available to the public. For example, the department's application forms, its website, and other publications. We also pointed out what a can of worms it would open if such email advice was actually adopted as formal policy. If you missed that fascinating addition, we will leave a link at the end of this video. This week the department caved in under pressure of how absurd the situation had become. They released this email to dozens of migration agents and lawyers, but unfortunately not to the public. The department has recently adopted a more beneficial approach to professional year as long as the professional year program was completed, meaning finished, within the 48-month period prior to the time of invitation. The applicant may be awarded 5 points. To avoid any doubt, the applicant could have commenced the professional year at a time before the 48 months prior to invitation. The time the applicant completed a professional year is the date listed on the official record of completion, which is issued by the authorized body of a professional year program delivery partner to the applicant. This policy will apply to all on-hand applications as well as to those who have been invited in recent rounds. What a complete mess the policy section has made of this issue. This recent email is actually the way it's always been, 4 years from the date of completion. They are now, however, trying to fix their previous incorrect advice, but doing so in a manner they are somehow being generous to us all by making a more beneficial approach. Simply amazing. What they should be saying is, sorry, we stuffed up. But like all government departments, there is someone in the Immigration Department trying to save their backside. And why is this an interest to all of you? Because visa applicants require certainty of the rules and policy in place before applications are made. The courts in Australia have in fact demanded this. Federal court rulings over the years have stipulated that a visa applicant must be made aware of the rules before an application is made, and the department cannot shift those rules during the processing of visas. There must be certainty for applicants before they spend their money to apply. What this previous policy email did was to create uncertainty. It created a facade of a policy that never was. It frightened people away from applying who have every right to apply. So many have missed out on their only chance of gaining a residency visa. The New South Wales government was the only state government foolish enough to follow this email advice, denying certain PYP certificate holders the 5 points they deserve. Many people even applied twice for the 189 visa because they were uncertain what to do. They applied once with the PY points claimed, and then because of what that email advice said, they put in a new EOI with 5 points less and obtained a second invitation and applied again. Will the Immigration Department refund this wasted second application fee of $4,240 for a single applicant? Those of you who have not applied after receiving an invitation because of this incorrect advice should apply as soon as possible while your invitation is still valid. Unfortunately, not everyone watches my channel, so if you know anyone out there who has been affected by these circumstances, contact them straight away and let them know. The only major law change this week was the Immigration Department is softening the character provisions known as Section 501 of the Migration Act. In Section 501, there are powers that can cancel a person's visa if you have a substantial criminal record. For the past 7 years, the previous Liberal government has been cancelling New Zealanders' visas in Australia and deporting them across the Tasman, even though many of them have never lived in New Zealand or even have family there. On the 3rd of March next month, a more realistic, compassionate approach will begin, as the News Hub program outlined.
Emma, what are these changes and are they what the New Zealand government has been asking for?
Well, Ingrid, these are the biggest changes to be made since Australia started deporting people under that 501 law back in 2015. I have just had it confirmed from the Immigration Minister office here in Australia that they are now going to take into account just what connection these people have with New Zealand. They'll take into account how much time they've spent living in New Zealand. If their formative years have been spent here in Australia, then that will be a huge part in their application and whether they will be deported or not. And with that also comes what connection, what immediate family they have here. If they have children living in New Zealand, that will also play a really large role in whether they're deported back to New Zealand or not.
No doubt these changes to Section 501 have been long overdue. According to the Federal Education Minister Jason Clare, Australia has broken the back of the visa backlog on student visas. In his press release, he claims, "We have broken the visa backlog. In May of last year, it was taking 40 days to process offshore student visas. Now it takes just 14 days. He was also busy commenting on Sky News this week, saying that China's move to ban the online study of overseas degrees will bring benefits to Australia, but he wants to diversify away from depending upon China.
If you couldn't get here to study, it's one of the reasons not to study at an Australian university. This decision's going to help us, but it'll help the US and the UK as well. If you can get on a plane and get here, more people, I suspect, from China will want to study here. But I want to make sure that we're diversifying, that we're not just encouraging people from China to come back, but we're encouraging more students from all around the world to study here. I'll head off to India in the next few weeks, working with the Education Minister there on a mutual recognition agreement, so we make it easier for students to study here.
The Australian newspaper reported that unless Australia can sharpen their visa programs, including targeted visas focused on specific skills, smoothing visa application processes, recognition of overseas qualifications, and a clearer pathway to permanent migration, we will be struggling to attract the skilled talent we need. I guess that about sums up all the things wrong with the current Immigration Department's visa system. It was reported in the Financial Review this week that India has led the charge for the first time over China in applications for student visas to Australia. Well done, India. This large influx of international students has brought refreshed hope for the casual workforce needed to run our cafes and restaurants, which Australians like to spend most of their free time in. And finally, we have to comment on the very disturbing report by the ABC regarding how international students are being forced to pay up front for emergency medical care before being treated. I thought these sorts of stories only came from America. What sort of country are we becoming? It's a shameful reflection on the treatment of our international visitors. It should be noted that student visa holders have mandatory medical insurance, so why are hospitals forcing them to pay up front is really just an insult. We can do better than that. Well, that's enough for another busy week here. These recordings are finalized late on Friday night, and the editing is done overnight by our incredible editor Constantine, so you have the program ready for Saturday night releases. A big shout out to Constantine, who took over the editing of our channel at the beginning of last year and has done an amazing job. Thank you from all of us, and many of our viewers I know feel the same. Don't forget to hit that like icon to support the work that we do here. If you need help, call the office to make a time, or you can book online on our website. As always, take care out there, and I'll see you next time. So bye for now.